To the left and right.
Test. Testing. Testing. Testing.
Good morning. Please be seated. Well, we are pleased to be here in Holbrook at Holbrook High School on the road. It's something we enjoy doing, and I'm positive council enjoy doing as well. So let's just start. We're here for oral argument on State Farm versus Balzan. It's our number CV-24-0140. Each side has 20 minutes. Council, you'll have to keep your time yourself for whatever rebuttal you may choose to use. A couple things in here for my colleagues. When you want to talk, don't forget to press the button and then unpress it so that the system works. So with that, Council, please.
Sorry. May it please the court. My name is Mick Levine. I represent Connor Balzan. I appreciate the opportunity to come out here to Holbrook in order to be able to argue this case. It was a beautiful drive up and really appreciate being able to get out. Thank Unfortunately, though, it seems every time that I travel, I forget to pack something. And this time I forgot to pack shoes. So I'm wearing my tennis shoes. I hope the court won't hold it against me. Um, we're obviously here in order to talk about Connor Balzan and his case with State Farm, not about my shoes. So let's talk a little bit about that. Uh, the statute issue in this case indicates that if multiple policies or coverages purchased by one insurer on different vehicles apply, then the insurer may limit coverage. The statute specifically says purchased by one insurer. In this particular instance, we have two insureds purchase coverage. We have Russell and Kimberly, Connor's parents. They purchased multiple coverages, more than two, but we're really here just talking about two. And so, under the plain language of this statute, multiple policies or coverages were purchased by two insureds. Because they were purchased by two insureds, they get multiple policies or coverages. In this particular instance, they get two UIM policies. Now, State Farm says no. 1 plus 1 in this instance equals 1. They say that the Balzan parents only count as one person. Now, they say that because of a couple of different reasons. The first reason that they say that is that they're purchasing these policies with community property funds. Now, I will gladly admit this is community property funds, but the statute doesn't speak to purchasers, it speaks to insureds. And here we have two insureds. Doesn't matter how many purchasers we have. It doesn't matter if we have 50 purchasers all purchasing insurance from one pot. What it talks to is whether or not the coverages are purchased by one insured, and we have two insured.
Mr. Levine, one of the statutes for statutory interpretation says that when you have a singular, we read it as plural. So applying that, would we read in subsection H, one insured as being one's plural insured, so that you're talking about as a unit, everyone insured under one policy?
I think that one insured is much different than word ones or insured, which the legislature could have chosen to use if that's what they wanted to put there. They could have put purchased by one insured, or excuse me, they could have put purchased by insured, or they could have put purchased by multiple insureds from the same fund. But they didn't put that. What they used was the very specific word, one insured.
Well, what do we do? Well, from their point of view, they wouldn't need to say multiple because they have the statute. Was it 1214B that says when we have the singular, singular means plural means singular. So what do we make of that?
But the thing about that, though, is that here they used a very specific word. They used one. They didn't use a. They didn't use an insured. They didn't use a insured. They didn't say the insureds. Instead, they specifically chose a number, one.
Council, excuse me, because one way to read one insured is that one refers to a numerical number. But there's another way to read that where one is treated as an article, sort of and if we were to read it that way, because if we read it that way, we can sort of make sense between subsection H and subsection B, and that named insureds is who's being referenced when we're looking at one's insured. Or do you think that that's a ridiculous or logical? And I'm inviting the questions.
Um, and my thought on that, Your Honor, is this. If the legislature intended it to be plural, they could have used an article such as "an" or "a" or "the," and they could have used the word plural, insured, but they didn't. What they chose to use was a singular number, one insured. And by using the number one insured, I think they meant one insured. Now, we can try and parse language. We can try and say, okay, well, singular is plural, plural is singular. But the problem with that here is that they didn't use an article, they used a number.
Well,
Numbers mean something when you, as judges, are trying to interpret this language.
even using it purely numerically, if you have multiple insureds, such as Russell and Kimberly, why isn't Russell one insured and Kimberly is one insured?
Sorry, button issue. I would tend to agree with you that each one of them is one insured. That makes two insured. So when we're looking at this and we're saying, okay, how many insureds do we have purchasing insurance? We have one insured with Russell, one insured with Kimberly, two insureds.
Just, one concern I have is that, I mean, it seems like that interpretation might open up things so that it really vitiates subsection H and the whole stacking provision, because nothing would prevent then simply having, multiple named insurers, I suppose, on all of these policies so that every single policy can be stacked. Um, doesn't that just get rid of subsection H and the legislature's intention for having an anti-stacking provision?
Sorry, once more an issue with the button. I don't think so, and this is why. Well, the way that the statute reads is that if there's one insured, they get one policy, regardless of how many policies they actually purchase, providing that they follow the required statute as we discussed in CSAA versus Franklin. But if there are two insureds, they can stack because there are two insureds. Two insureds are being rated, two insureds are paying premiums, two insureds are paying for this coverage. So when we're looking at this, if we're trying to parse out why the legislature did it, there's one simple way to try and go about it. And that is that they wanted to create a simple rubric for judges and insurance companies and insurers to be able to understand when they're determining how many policies do they get. One insured, one policy. Two insured, two policies. Three insured, three policies, and so on. Insurers take that into account when they're determining how much they're going to charge for premiums. And they stack these policies. If so, do we need to charge extra in order to accommodate that? If they can't stack these, does the insured get a discount? Because now they're not going to be exposed as much as they were. We provide a rubric, the legislature provides a rubric for everyone to be able to understand exactly what's at risk and exactly what's not at risk. And by using clear language, such as one insured, it makes it very clear for the insurance companies and for the insureds and even for the insurance agents to make a determination as to what the risk is and how much they need to be able to charge in premiums to accommodate that risk.
Well, suppose Kimberly and Russell had a business partnership and that partnership purchased multiple policies. Would we still look at this the same way because there are two partners, but one legal entity?
I think if we were talking about one legal entity and the legal entity is the insured, then we would have one insured. If we have two people, we have two insureds. What we're really looking at here is who's being insured under this policy, who the insureds are. Here we have Russell, and we have Kimberly, two insureds. But in your instance, Justice Bullock, what you're talking about is a partnership, a legal entity. That legal entity itself being the only named insured under the policy would count as one insured. Now, one other reason for this, and kind of way that I'm thinking about this when we talk about community property issues is this. If we're looking at, oh, well, the community paid for it, the community purchased two policies, which is State Farm's argument. Lindsay Court of Appeals said that case was vacated, of course, by this court. But if we're looking at the pot that's being paid out of, the statute really doesn't speak to that. It doesn't speak to whether or not there's one pot paying for multiple insureds. What it talks about is whether or not there's one insured versus two or three or four insureds. If the legislature wanted to say that it's all coming out of the same pot and counts as only one insured, the legislature certainly knows how to say that. Again, the idea here is that we want to keep it a rule that's nice, simple, easy for everybody to follow. If we were to do what the Court of Appeals did in this particular instance, they talked about whether or not the money comes from a joint account or joint funds or something like that. Then in every single instance where we have two insureds, we're going to have to do further inquiry in order to see where that money comes from. In this case, it's a married couple, right? Well, do they have a pre or a postnuptial agreement establishing separate property? Are they paying for it from separate accounts? These are all the types of inquiries you would have to make if you followed what the Court of Appeals said in order to determine whether it came out of the same pot or the same pocket, or whether it came out of two different pockets.
Counsel, on that point, I'll confess to you, I'm not swayed by the Court of Appeals analysis in this case involving community property. I agree with you. We vacated Lindsay, and I don't see that we vacated on the ground, so I'm not persuaded by that argument.
Okay, and I understand that, Your Honor, but in addition to looking at that, though, if we're going to be looking at where the money came from, then in every single one of these cases where we have two insureds and they're purchasing insurance, we're going to have to make further inquiry. By looking at just the number of insureds and just the number of policies that are purchased, we can easily determine how many policies are applicable to any particular laws. But if we look at community property or whether the money all comes from the same pocket, we're going to have to do a further inquiry every single time. Now, an
What
insurance company, I'm sorry.
why wouldn't it be, you're talking about simplicity, and that certainly, always has an allure to make it simple to apply. But why isn't it just as simple to say that one insured is the the whole, the unit of the whoever the named insureds are, be it a married couple, be it a father-son, whoever it might be, that that is one insured and that's being referred to in subsection H. Wouldn't that be just as easy to apply as your methodology?
Other than the fact that math tells us that two people are not one, I mean, it would be a simple methodology to ignore what the legislature wrote and to say, well, one insured really means two or five or 10, but that's not the language that the legislature chose. And if that's the language that this court is going to interpret into that one insured provision, then what's going to happen is that we're going to be talking about whether or not multiple insurers should have separate policies and whether or not each insured should separately insure their own vehicle through a separate policy, through a separate company, in order to be able to gain the full benefit of what it is that they're paying for. Because when it comes down to it, these folks are paying for UIM policies. They're not paying for a UIM policy, singular. They're paying for more than one. And the way that the legislature termed this is that if they're paying for more than one policy and there's more than one insured, they get the benefit of what it is that they're paying for.
May I ask a question? So I noted that subsection B of the statute that we're looking at refers to, it refers to the named insured, of course, but it also talks about all persons insured. What do we make of the fact that in subsection H that we're looking at, we didn't use that same terminology, all persons insured, one insured?
I agree with you there. Persons, plural, right? One insured, singular. And that, I think, is the difference that the legislature was trying to make in order to be able to make this nice, simple, easy for insurers, insureds, insurance agents, even the courts to be able to interpret, which is that two insureds, two policies, two coverages. It's that simple. When we start looking at whether or not there's one insured versus two insured, how exactly are we going to be able to parse that? What if we have two insureds, two married folks, as in this particular case, and they're dealing with their sole and separate property? Is that two insureds or is that one insured?
Counsel, I want to go back to a point you made at the outset of your remarks, where you mentioned that if individuals buy multiple policies, they could get a premium discount. Does that reflect, in fact, then, realization that they wouldn't be able to stack all of those policies and receive UIM coverage under all of them? But because they have multiple policies and they would be limited to choosing which one would apply, well, they're gonna get a discount on those premiums because they're not going to be able to recover UIM coverage in the same amount under every policy.
I don't think that that's actually the way that it works. I think that the way that it works is that each individual insured under the policy is rated according to their own driving record. We don't take a married couple and rate the married couple when we're doing insurance. What we do is we rate each individual, and that's how their premiums are determined. Is there a multi-vehicle or a multi-policy discount that's sometimes offered? Yes. What goes into that calculation is the fact that you're purchasing multiple policies from them. Does that also take into account whether or not there's not going to be stacking? That's something that the insurance company needs to make a determination on based upon what the law says. They need to determine what their risk is. And in order to determine what their risk is, they have to know, are they allowed to stack those policies or aren't they allowed to stack those policies? But with the plain language of the statute, it's easy to say they are allowed to stack those policies, and therefore they need to take that into consideration when they're determining the rate for UIM policies for those two individuals.
Well, counsel, under your interpretation, if we're talking about two separate people and not one entity, then why would we not read um, them as purchasing two separate UIM coverages, even under the same policy, right? Because we're talking about one UIM coverage um, separate, purchased by two people.
Right. And I think the way that the subsection H reads is that if they're from the same company, uh, then what would happen here is that if Russell purchased one policy and Kimberly purchased a different policy, if they're with the same company, the way that State Farm says the statute reads, they would still be able to prevent stacking. They'd have to actually go to a completely different company in order to get two UIM policies under State Farm's interpretation. But that's not what the statute says. I'd like to reserve the rest of my time, if I may.
You may. Thank you. Okay, is it Mr. DiCiencio, right? Close.
You and everybody else.
Going on? Sounds like it. May it please the court, counsel, ladies and gentlemen of Holbrook High School, my name is Joel DiGiancio, and along with my partner, Christopher Robbins, we are here on behalf of State Farm Mutual Automobile Insurance Company. Thank you for the opportunity to appear today in Holbrook. Under ARS 2259.01 subsection H, multiple insured individuals who jointly purchase multiple policies using community funds or shared funds constitute one insured. We would urge you to answer that question in the affirmative. However, if you opt not to do that, we would alternatively ask that you affirm the Court of Appeals decision finding that joint purchasers are subject to the anti-stacking provision and that choices made by the joint purchasers are binding on each other with respect to selection of coverage. But our point today, the question that you pose, that you ordered oral argument on, is the question of whether married couples and joint purchasers constitute one insured. And we think there's two approaches that you can get to that with the same answer. The first approach is just statutory interpretation. Um, this court has held that when we are interpreting statutes, we don't do a hyperliteral interpretation. We do a textual interpretation. And that's what you have recently held in recent cases. And so that's important because rather than doing a literal interpretation as the appellant is suggesting in this case, if we consider the uh, textual and contextual references to the statute, I think we reach a different result. So let me give you some suggestions there. What this court said recently versus Serrato is that we look for contextual clues that help us determine the statute's meaning with the goal of achieving cohesion and consistency. So in this particular case, what I would suggest to you is that the contextual clue at issue in this case is the fact that Arizona law treats marital communities and joint purchasers as one entity already. They already treat them as one. I can give examples. ARS 25-214 allows either spouse in the marriage to acquire community property, control community property, manage community property, and bind the community. So we
Council,
already treat
let me ask
marital
you a
communities
question
as one
here
entity.
before we go too far down the community property route, because I'm not persuaded by that argument. I think that confuses the circumstances that we've got here in trying to decide an issue involving insurance, and it's going to invite additional collateral litigation and trying to determine what the source of the funds were. Um, did the petition for dissolution occur before the accident or after? I'm more interested in taking a look at the relationship between B and H and trying to understand the relationship between named insured and one insured so that we can read this statute coherently and consistently, as you've already alluded to. And so I'm going to reiterate or re-ask a question that the chief did of your opposing counsel and look at ARS 1-214B, which provides guidance for us in interpreting statutes. It specifically says words in the singular number include the plural, and words in the plural number include the singular. So why can't we read named insured as named insureds and one insured as one's insured consistently and coherently?
Well, I think you can, but you still have to consider, and I think under your rules of statutory interpretation, you have to still consider the context. So let me talk about the issue regarding named insureds. There's case law in the state already that indicates that named insureds and insured are not necessarily the same person. In subsections A and B of the statute, in the mandatory offer, it refers to the named insured.
Let me pause you 1 second. I'm talking about named insured and one's insured, the link there is that in B, the insurance company has to offer UIM to the named insureds. And then in H, we're talking about the insurance, multiple policies or coverages purchased by one's insured. Plural there. You're not going to offer UIM coverage to someone who just qualifies as insured by definition of the policy.
Not required to unless they're a named insured.
Right.
And,
So that's, if I'm getting this wrong, point it out to me.
no, I don't think it's necessarily wrong. I think what the focus is contextually, though, using those rules of statutory construction, is that when the statute says purchased by one insured, I think what they're trying to suggest in context is that it's the source of the payment. When the source of the payment purchasing two policies is the exact same source, then it's one insured for purposes of anti-stacking. And if I may give you an example of how that works, I think you can see why that results in cohesion, consistency, and fairness. Let's say that we have three scenarios. The first scenario is a married couple who purchases two policies with community funds. One car is driven by the husband, one car is driven by the wife. Second scenario, you have an adult daughter who lives with her mother. They open a joint bank account. They both put money in the account, and they use that account to purchase two policies. Then the third scenario is you have an individual owns two cars. Let's say they're a realtor and they have a fancy car they take clients around in. They have a truck they use on the weekends for recreational purposes. In all three scenarios, the source of the payment of those two policies is exactly the same. Funds in example A, joint funds put together in scenario B, and then of course in scenario C, it's an individual's income. If an accident happens and the wife is injured as a pedestrian, she gets interpret the statute to separate these insureds and not allow the anti-stacking provision to apply, then that injured spouse gets to collect under both policies, as how it suggests. In example number two, the same thing. Let's say the daughter's injured as a pedestrian. If you interpret the statute as they suggest, she gets to collect under two policies. But clearly under number three, the individual doesn't. They're limited to one policy. And so by using the source of the payment as the definition of what one insured means, the source of the payment is exactly the same, you're achieving fairness because, and it's even more onerous on a single individual because they only have one person paying premium on two policies, where in you have people pitching in. So you want to treat them similarly.
I'm not sure, could you explain a little bit more about why it's the source of the payment is, has such really is determinative under the statute? Because the statute doesn't say anything about payment or where it comes from. So in your second example with the adult mother and the adult mother, the mother and the adult child, there's no, they have a joint account, but they could just as easily have separate accounts and they each just pony up 50% of the premium every time it comes due. It sounded like under your scenario, it's okay, it's coming from different sources, therefore they'd be different insureds. Could you explain a little bit more about one, where in the statute does it indicate that the source of the funds has any bearing on the interpretation of the statute? And two, am I correct under your scenario number two that just because the sources came from 50% from each person, that they'd be now two different insureds?
No, in fact, I think what I should correct is it's not the payment, it's the purchase. I guess the purchase is what's important. So when the source of the purchase is exactly the same in those scenarios, then they should be considered one insured. Now, quite frankly, to answer Justice Montgomery's concerns that he's raised is for 30 years, we've sort of followed the rationale of the Court of Appeals in Lindsay. This issue is, it's not about whether you can cite a vacated another ground's opinion. It's just that rationale, and that we always felt that rationale was appropriate. They're a married couple, so they're a community, and that's what the Court of Appeals held in Lindsay. And there has been no case since that has said otherwise. So, and in fact, cases like Yeager versus State Farm and Giannini, those courts have sort of assumed that because that issue never came up in those cases, and those were stacking cases involving married couples. So I think it's the source of the purchase is what we should focus on. So in scenario number two, it's not the funds are coming from two different people. They're coming from one source, which is a bank account, a joint bank account, which is shared funds, joint funds.
But it goes back to, I mean, I thought you had me when you said we're looking at it as a single purchase, but then you've kind of gone right back to okay, where that the funds come from. And that's what I'm not understanding. One, why is that pertinent? And where is that in the language of the statute? Any indication about where it came from? This goes back to Mr. Levine's point. Then we're going to start having people start to look at, well, where did the money come from and how did it go through, and it seems very complex and ripe for loopholes when you do that. So in the second scenario, if you had two different sources for the funds, independently controlled by two different people, it's not a single source then. And so I guess I'm not understanding where you're coming from on
Well,
that.
and I think the reason we sort of address that is because that's basically what the Court of Appeals decision in this case is, that if people use joint shared funds, now they didn't really explain, the Court of Appeals didn't really explain it or analyze it other than to say if joint purchasers, and joint purchasers could, so community property could be joint purchasers, but not all joint purchasers are necessarily communities, marital communities. And so they kind of lump that together, that if the policies were being purchased by people who shared funds, then the anti-stacking provision applied. And that's why we're asking you alternatively, if you don't want to find that a marital community and joint, shared funds are one insured, then we would ask that you at least affirm the Court of Appeals, where the holding is that joint shared funds are subject to the anti-stacking provision. So it is complicated because the statute doesn't say it, but in context, that's why we raised the contextual issue, because when you look at those different scenarios that could happen, it's unfair to the single person that purchases two policies when it's really the same factual circumstance. And so I think it's easier in the marital community situation because there's a presumption under Arizona law that all property purchased with community funds on community property. And there's no dispute in this case that an insurance policy is community property. So it's a lot easier. And I will tell you, as somebody who's done this work for 30 years, 99% of the cases that we run into in marital communities, not adult daughter with mother. It has happened, and I've handled cases where that's been the claim. They pooled money together and bought two insurance policies. But the vast majority are the community property situation. And so that's why we had urged all along to adopt the same rationale as the Lindsay Court of Appeals, even if you don't, buy that you can cite that case.
So what with the adult, uh, uh, two adult, a mom and a daughter, both adults, both named insureds, shared funds to purchase, were jointly purchased without inquiry into where the funds came from. So what is the legal rationale that would allow that to be considered one insured?
Because the source is the same. I think it gets back to the questions that were asked about discounts. So when you go and typically insure multiple policies under certain consistent situations, same named insureds, same people purchasing it, you do tend to get discounts, and there's a reason for that. There's a reason one entity, one set of insureds buys multiple coverages, they tend to get discounts, and the rationale for it is the legislature allows it. And it kind of leads me to the other approach I wanted to talk to you about, which is the last time this court looked at the statute, you found it to be ambiguous. So in the Franklin case, this court found that different provision, different word within the statute, but the same statute you found ambiguous. So let me talk about.
Before we do that, so then just so that I'm clear, if two people are not married but they're living together, but they pay out of a joint account, then they would be subject to the same community property rationale that you mentioned.
That's what we would argue. That's why we would say the inquiry should be, is the source of the purchase of the two policies exactly the same? Does it
But if
come?
the two same people who live together but are not in a joint account purchase insurance, then we would not be under the same
Well,
purpose.
that's what the Court of Appeals suggested. The Court of Appeals suggested that if there are joint purchasers and they didn't delineate between non-married people and married people, they just said joint purchasers, which is similar to I think the example, Justice Pollack, that you gave of it. What if they're a business? It's still one, whether it's one entity or one entity that's paying from the same source.
Just so that I understand, does the insurance company inquire into whether these funds are coming from a joint account when they're not married?
Well, there's nothing in the record that would suggest that one way or the other. So I kind of hate to speculate on that, but based on my knowledge of insurance, typically, yes, they do, because married people get rated differently than single people. Maybe that's a fiction, but maybe they're safer drivers when they're married. But I think they do inquire into that. But in this particular case, I mean, we get far afield trying to determine whether mothers and daughters pitching in should be subject to the anti-stacking provision. But in this particular case, it is a marital community, and
Counsel,
this case
before you
originated from
continue
that.
on that, I know you want to get to the point. You mentioned that if we were to interpret this differently than what you're proposing, that a single individual who purchased multiple policies to cover different vehicles, that would somehow be unfair for them. And question when I ask you is, well, wouldn't that person get a multiple vehicle discount or a multiple policy discount? And doesn't that somehow factor in then that they wouldn't be able to take advantage of multiple UIM coverages under that scenario?
Well, it should be because that, and you're right. That's the argument we typically get in response to these cases. Is when we investigate a claim and we determine that, say, the source of the policies is community property, and State Farm, like it did in this case, takes the position that only one policy applies, the policies don't stack. Then what? Because it's community property, sort of the Lindsay Court of Appeals rationale, they usually come back and say, well, had we known that, we would have purchased them differently, or something like that. But if they had purchased them differently, they probably wouldn't have gotten the discount. But people don't buy insurance anticipating how policies are going to apply when they have a loss. They buy insurance to get the cheapest rate they possibly can and pay the least amount, hoping that they never have to cash in on it.
Well, I bet after this case, people are going to start looking at what kind of coverage they get when they go to buy.
Well, I mean, it's a big issue, and that's why I think we're here is because we have the Lindsay Court of Appeals gave a rationale that said, look, um, community property laws, insurance policy for community property. In that case, one policy, the name was Janice Lindsay, one was Walter Lindsay, and the other was both. And that's why we don't use the named insured, typically, because case law in this state says that the named insured is not necessarily the insured. If the legislature wanted to make it one named insured, they would have said that, and they didn't. Go ahead.
Anxious to hear rationale two, just in case rationale one is not convincing everyone.
Sure, you bet. And so when this court found the statute ambiguous in Franklin, what you did is you applied secondary interpretive principles. And what the court did in that case is they said, we're going to look at the statute's context, we're going to look at the statute's history, and we're going to look at the statute's purpose. We're going to use that to help interpret how the statute should be interpreted. So in this particular case, let's do that. If we look at the context and the history of the UMA, the Uninsured Motorist Statute, this court back in the 80s employed or developed a theory called portability. Now, the word portability or portable doesn't appear anywhere in the statute. Nothing in the statute says portable or portability. Portability means that insurers were no longer able to limit coverage to circumstances where the insured was in the insured vehicle. As the cases Higgins and Calvert famously say, the insured gets this coverage whether they're in their own car, somebody else's car, or sitting on their porch. And so that was one specific limitation insurers were not allowed to do. The real issue with portability, though, is because now coverage follows the person and not the car, virtually every policy is in play. So in any claim, any given claim, depending on how many people are in the family, but certainly in the context of a married couple, there's almost always two policies, almost always. And in those situations, uh, we have that issue where we have to determine what policies apply. Well, under portability, either policy could apply. The insurer would get to select the one with the highest limit. So that's an example of the history. Another example of the history is other insurance clauses. In Brown and Rashid, I think also in the 80s, this court held that insurance companies couldn't limit coverage by clauses that said, hey, if you have coverage from another source, you don't get coverage under this policy. And the court said, no, you force them unless the insurance is fully compensated. So through the history and the context of the statute, insurers have been limited in what they can do to limit coverage in a rational, reasonable way, except for anti-stacking. This is the only limitation in the UMA that's permitted by the legislature. And in fact, I think this court and other courts recently expressly held and recognized that this is the only limitation. So if this is the only limitation that the legislature allows insurers to limit coverage, it must be important. And so we'd want to look at the purpose of it. I think employing the secondary interpretive principles, what we're trying to accomplish is an interpretation of the statute that doesn't render it meaningless or illusory. And so that if you look at the example that I posed before, it kind of does. And I think Justice Timmer, you raised that issue in the appellant's argument that if married couples are separate insureds and aren't subject to stacking, every single case involving married couples will always involve stacking. Insurers will never be able to to exercise the right that the legislature gave them.
Now, this court has repeatedly stated in Sharp and Taylor that the legislature intended a broad application of UIM coverage. How do you respond to that principle that's been articulated historically throughout our case law?
Sure, and that's kind of exactly the point of my argument in the context is that this statute has been liberally, it's remedial in nature, it's been liberally construed for its entire varied, storied history over the decades. But with anti-stacking, and that's why it's important to make sure that the purpose of anti-stacking is not frustrated, because it's the only example, the only limitation in the statute that the legislature gives to insurers. So any insurer that has a provision that does not comply with the statute is not enforceable. Other insurance clauses that were contrary to portability are examples, which is why I mentioned them. I mentioned those examples for that exact purpose to show how this limitation granted by subsection H is unique. It's unique because it's the only one that allows it. And so by I'm sorry, I'm out of time. Let me just very quickly sum up. But if you find this statute ambiguous, because that purpose is unique, it needs to be furthered. And if you allow married couples to stack policies, you do basically render the provision meaningless and illusory. So we would urge you to hold that when there are shared funds paying purchasing policies, whether
Thank
it's a marital community or not, that
thank you,
are one
counsel.
insured.
Okay, Mr. Levine.
I think I'm still on. Oh, good. So a couple of quick things. One, earlier in the statute, they refer to persons. And this instance, they refer to one insured. Persons, plural, one insured, singular. There's also a part in this very statute, in this very section, that also refers to one. The statute says if multiple policies or coverages purchased by one insured on different vehicles apply to an accident or claim, the insured may limit the coverage so that only one policy or coverage selected by the insured shall be applicable to any one accident. Three times they say one in this statute. Are we going to interpret just the first one to mean that it's plural and ignore the other two and choose that those mean singular? It's inconsistent within that statute to give different meanings to the word one. A couple of other things, just real quick. If we are going to say that this is ambiguous, you're looking at other context. The other context we have in order to determine how to interpret one come from the two other times that word is used in the statute, and earlier in the statute when we use the word persons, plural. Also, I heard a lot from State Farm's counsel about the source of the payment, and I agree with you, Justice Timmer. There's nothing in this statute about the source of the payment. It doesn't talk about purchasers, it talks about insureds. And that's what we're looking at, is how many insureds are there and how many policies are there. Thank you.
Okay, thank you. I thank all counsel for their briefing in this matter and their argument. We're going to take the matter under advisement and will issue a decision in due course. I want to thank counsel particularly for traveling out here. It's important, I think, that people see counsel arguments and see, frankly, good argument and how the process works. So we all appreciate you all coming to Holbrook today. So what we're going to do now is, and to let you know, we're going to have a Q&A after the next argument. We will not be talking about this case or the next case, it's just other matters. But you are welcome to stick around for that, or certainly welcome to go if your choice. Now we're going to recess. We're going to stay on the bench and let the next group of counsel come forward for the next case. So thank you.